road today, Casey Ashmore, and we're doing a deep dive on Texas civil litigation, and going to talk about all the intricacies of that entire process, in the hope that it brings some education and some light on what can be a very confusing and muddled subject. But before we start, as I have done for the last several months, we're giving special acknowledgement and sending prayers of healing to our nation, who is, our friends and neighbors and countrymen are hurting because of the unrest from the tragic death of Mr. Floyd, and how we are all living and coming together as a nation to live up to the rhetoric of our American Revolution, and that we are all created equal under God. And also because of the unending economic hardship for many of our friends, neighbors, and countrymen, because they cannot provide for their families due to the coronavirus pandemic. The last video series, I was speaking about the discovery process, and I like to analogize that to the second quarter, right? That's right before halftime. You want to keep the game close. You want to know where all the facts are. You want to know the good facts and the bad facts, and that's why the parties exchange questions and answers, and sometimes interview each other in a sworn deposition setting, which is, again, it's a formal court testimony situation, but it's like an interview. The other side gets to ask questions, and if the case merits it, you as the claimant may want to take the other side's deposition as well, and thereby learn what defensive theories they may allege through sworn testimony at trial. And that's a real big advantage that you get in civil litigation, is that you get to know, for the most part, what all the witnesses are going to say at trial through the discovery process, either through written interrogatories, which are questions that are sworn to, just as if they were answered in court, and also through deposition testimony. So you don't get that opportunity in criminal law cases. You don't know what the other witnesses are going to say until they're actually on the stand. So that's a big advantage in civil litigation, is that the parties are put in as an equal a position to know all the risks before trial. And the thing that almost all, without question, judges will require is that the parties attempt to resolve the case through mediation, where they go and they hire a third attorney to sit, and it's not really like playing judge, but in a lot of ways it is, because that attorney will make predictions on how a court might rule on the facts of the case and the risks in the case. This is a little more favorable for you, this is a little more favorable for that side. Here's a potential compromise that you can perhaps live with. Now, a lot of cases, the vast majority of them, settle at mediation or outside the courthouse somehow, and the reason why is because they should. It's a lot cheaper. It's a result that if both parties compromise, and by the compromise they give up some rights in exchange for a deal they can live with, and thereby end the litigation, end the lawsuit, end the contentious. And otherwise, the next step is pretrial motions, and I'll get into that more in the next segment. But again, thank you for watching. Please like, subscribe, and share. Leave me a direct message, and or a question or comment, and I'll reply back, or make it the subject of a subsequent video series, or both. Thank you again, and I'll see you guys on the road for more on Texas civil litigation.